Our case is being sent back to USCIS. Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States out of our offices in St. Louis, San Diego, and Washington, D.C. This is the timeline. This is how it goes, and it really, really bums people out. So, couple falls in love, they file a fiancé petition or they file an I-130 spouse petition, and they file that with USCIS, and it gets approved after many, many months. These days, about a year. Then the case gets sent to the National Visa Center. The couple pays additional fees. They file the DS-160 or the DS-260. They feel like things are making progress. Then the case eventually gets documentarily qualified, and then whenever a slot opens up at the embassy, the case is set for interview, and the interview occurs. A lot of times, the foreign national receives a 221G administrative processing notice, and then eventually, after pushing, maybe after a lawsuit, after bugging them, or just after the passage of time, they receive word that the case is being sent back to USCIS for possible revocation. That's what we're talking about in today's video. Now, this, of course, is a real kick in the head when this happens. You've waited, at this point, probably around 2 years, at least a year and a half, to have your spouse or your fiancé to have their case approved. The embassy, for some reason, doesn't like the relationship. Maybe they think there's too much of an age gap. Maybe they don't believe that the marriage is for reasons of love and not for an immigration benefit. Maybe they don't trust the foreign national and they think that they're taking advantage of the U.S. citizen. We see that a lot in spouse cases or Middle East, North African cases. We see this a lot where USCIS sort of holds the marriage to a higher standard or holds the fiancé relationship to a higher standard and says, we don't like this case so much. We know USCIS said that this was a valid marriage, but we're going to send it back for possible revocation. Now, in my mind, in a lot of ways, these are just delay tactics. These are just tricks that USCIS and the State Department have in their bag of tricks to slow down the immigration process. But the State Department in particular uses this. Now, when that happens, you've now waited 2 years. Your case is going to take at least another 6 months to get back to USCIS and for them to begin working on it again. You're going to be receiving a notice of intent to revoke, and you're going to be given the opportunity to prove that the relationship is indeed valid and is indeed for love and not for immigration purposes. Now, sometimes the foreign national, when they went to their interview on the DS-160 for the fiancé or DS-260 for the spouse, they've said things that can't be fixed, that can't be overcome. They've made dumb statements, or they've said things that are just flat out wrong. They can't be cured. But in the vast majority of cases, I would say 90% of the cases that we've handled where USCIS has said, hey, we've received the file back from the State Department and we might revoke your case, we've been able to overcome it. Usually it's just submitting more marital evidence. And I think in my mind, USCIS sort of rolls their eyes and said, oh, there goes State Department again, sending the case back to us for revocation. But for the most part, unless, like I said, there's some fundamental flaw in the relationship, some legal impediment that keeps the foreign national from getting the case approved, for the most part, you can get this approved. The problem is you're talking 6 months to get it back to USCIS, then another 6 months for you to reply to the notice of intent to revoke and for them to do it and send it back to the State Department for further processing. There sometimes gets to be this little battle between state and USCIS, and that's a real problem. So this is definitely not something that you want to happen. We have had this happen in lawsuit cases, or we've also had cases where USCIS received the notice of intent to revoke, or they never actually received the file back from the State Department, but the State Department said that they sent it. We have filed lawsuits on those cases, and the good thing about the lawsuit is that compresses that time. If we've sued USCIS and the State Department, they can't be playing football with your file and sending it back and forth to each other. They have to get moving on it. So lawsuits are effective in these situations, although you have to handle it a little bit differently. Hopefully you won't be going through this, but if you are going through it, and if you had a fiancé case and it's up for possible revocation, I'm probably going to advise that you ditch this case, get married, and start over. It's much easier to file a stronger spouse case than a fiancé case, and USCIS and the State Department are playing lots of games on fiancé cases, as I've covered in other videos. Hope you found this helpful. If you're thinking about working with a law firm that knows what they're doing, that can help you with your immigration matter, give us a call, 314-961-8200. You can also email us, info@hackingimmigrationlaw.com. Be sure to find us on our Facebook group. It's called Immigrant Home. We also have our YouTube channel that you can subscribe to so you get updates whenever we make new videos, and we'd love to see you there. And also, we'd love to see you on our Immigration Answer Show, where I go live 3 or 4 times a week trying to answer as many immigration law related questions as possible. Thanks for watching, and we'll see you next time.